Greetings and welcome to Law of Evidence, Economic and Financial Facts from American Jurisprudence. Today we're going to be going over the economic and financial facts as applied to judicial notice, as we've been going over. And this is in Chapter 3, the economic and financial facts. That can be judicially noticed. So we're on Section 64 generally. I hope everyone's been having a good time through this exploration of the law of evidence, because just this section on judicial notice alone has been quite elucidating as far as the way facts are considered in court without having to go through the process of the regular adjudication back and forth, etc. And understanding where these apply the best and where they don't apply really helps to build a good case strategy and structure. But that being said, nothing in this broadcast to be construed, misconstrued, or used for anything legal, lawful, professional, personal, financial, tax, or otherwise. So please don't do this at home. That being said, let's proceed. Section 64, generally. The courts take judicial notice of generally known financial and business conditions at given times. The courts may also take judicial notice of the existence and effect of general domestic, economic, or financial panics or depressions. Panics like a pandemic, I guess, too, such as the general business collapse following the stock market crash in 1929 and the concomitant unparalleled demands for relief. So this is referring to the 1929 stock crash. But remember now, this is from a 1998 edition of American Jurisprudence, so it's only up to date as far as that. And, I hate to say this word here, concomitant. So, okay, so this is just to do with the association, or to go along with the company. It's just harder to say than to know what it means. It's best to be used for writing. All right, the generally depressed condition of a major national industry is a proper subject of judicial notice. So think about this as this applies today. Remember, this is written in 1998, but this probably goes back far further than that, because we're already referring to the stock market crash in 1929. But now we've seen a higher frequency of these kinds of events. And now to know that the courts do take judicial notice of generally known financial and business conditions at given times, and the effect of general domestic, economic, or financial panics. The generally depressed condition of a major national industry is a proper subject of judicial notice, although the courts may not take judicial notice of the exact extent or percentage of loss of business that needs to be litigated of any one particular industry or business enterprise. In addition, a court may take judicial notice that the employment opportunities in one area are greater than those in another area. Depreciation of property values during periods of economic stress, and the fact that during a period of severe economic depression, mortgagees were urged to be lenient and to refrain from foreclosing mortgages, are matters which may be judicially noticed. This is 1998, remember. So think about this in that context. Depreciation of property values during periods of economic stress, and the fact that during a period of severe economic depression, mortgagees were urged to be lenient and to refrain from foreclosing mortgages. And that's footnote 23. How long ago was this one here? This is Marsh versus Arthur C. Marsh, Oregon. Law Review doesn't have a year in here. All right. So all matters which may be judicially noticed. Similarly, courts may judicially notice the fact that economic depressions have proved a motivating factor in the enactment of legislation designed to alleviate conditions resulting therefrom. Economic depressions have proved a motivating factor in the enactment of legislation. Footnote 24. West Coast Hotel Company versus Parrish. Another interesting one, too, to look into. All right. Some pretty good ones here already we've come across here. Business and price trends are also the subject of judicial notice and may impel the court in a proper case to fix the amount of return upon the investment of a corporation. Impel the court in a proper case to fix the amount of return upon the investment of a corporation. Wow. In establishing utility rates, courts have taken judicial notice of conditions incident to an economic depression, such as changes in value, consumption of commodities, and reasonable return on invested capital. Wow. So, as you see here, we're heavy into the economic ramifications of judicial notice. And now, as you see how complex it's getting, it's a good thing that they brought it this far into it, because as we've gone over different forms of judicial notice, the economic and business ones get to be the most complicated, it seems. Luckily, we already passed up the attorneys and the insurance one, but those are just seem to be just their own level. But this one here seems to be even more intricate. Section 65, World or National Economic Events. Let's pop over here to the chat before we go on to this section. Bill Thomas says, following the fine threads of legal logic begins to reveal the complex fabric of our system of justice. Indeed, the patterns are woven through a long history of the peaceful resolution of disputes and conflicts. And of course, as we read earlier, is to ascertain the truth and to ensure a fair process. And I think if we bring all that together, that's where the law of evidence comes together, where the rubber meets the road is what we're reading right here. So this is how we bring that concept, that ideal, into action on day-to-day events with the occurrences that the courts have to deal with every single day. Some courts took judicial cognizance of the Great Depression of the late 1920s and 1930s, including the stock market collapse, the general economic and financial collapse which followed it, and the ensuing adverse business and financial conditions and distress, and widespread unemployment. More recently, courts have taken judicial notice of major financial events, such as the Arab oil embargo of 1973, the Emergency Petroleum Allocation Act, and their impact on the petroleum industry, the dramatic decline in oil prices and profitability of drilling for oil and gas in the continental United States after 1981, and the unusually poor state of the nation's economy during 1974 to 1982. It seems that history doesn't exactly repeat itself, but oftentimes it rhymes. Let's continue here. These footnotes here, just the cases, which are extensive. Oh, here we go. The embargo and the act are adjudicative facts, judicially noticeable, in an action seeking damages for breach of contract to pay commissions for locating a purchaser for crude oil. Noting that 1974 to 1982 were aberrational years, marked by recessions, double-digit inflation, and extreme oil prices. Thus, this period should not be used as the standard by which a court should adjust an award of damages to anticipate the effects of inflation. All right, we're on to section 66, banking, financial transactions, generally. This one's going to be really good. But let's go to the chat here. Bill Thomas says, I remember only being able to fill a gas tank on alternate days based on odd or even license plate in the 1970s. Indeed, I remember that one too. And the lines, gas lines too, even with the even and odd days, that was to alleviate the lines, but there still was. Amazing. And to think how much consumption there was idling in those big V8 cars back then. And there was still leaded gas, so some cars were still using leaded gas, so everyone's breathing the leaded fumes. Yeah, those were the good old days. Who wouldn't love to smell that leaded gas? All right. Courts may take judicial notice that it is not normal business practice for a corporate payee of checks to endorse them in blank and deliver them to third persons. Wow. And that for a bank to accept such checks for deposit in a third person's account violates reasonable standards of banking practice. Wow, footnotes 37 and 38. That's Paragas Incorporated versus Estate of Taylor. Huh. And then there's a Belmar Trucking Corp versus American Trust Company. Here's that Belmar Trucking again. Footnote 38. Annotation. Banks reasonable commercial standards defense under, oh, here it is, UCC 3-4193. Good one there for the notes to look into later on the UCC streams that we do. So we'll put that down for the notes there and see if that's up on the agenda. 419.3. All right. Well, let us proceed. Finance companies generally retain car title certificates. Car title certificates, not the title, certificates in connection with chattel mortgages. So mortgages on movable property. Institutional lenders customarily dictate the form and language of the documents used in a loan agreement. That's the distinctive character of the chattel loan business. And here's the marriage of Tammin. It is common knowledge that deeds of trust are bought and sold in the ordinary course of business. State national banks seek the privilege of acting as fiduciaries, administering the estates of descendants and incompetent persons. Wow. Interesting one there. All right, we're on to section 67. Money, changes in cost of living. Light aircraft still use leaded fuel, but it is lower levels. Oh, interesting. I always thought that the leaded fuel was bogus. It wasn't necessary at all. There were better additives used rather than that triethyl lead. But then again, who's to really say? In general, the courts take judicial notice of the character of money and popular language in reference thereto, as well as the value of the various forms of money. In the past as well as in the present. Gaze gold. This is very interesting here. The courts take judicial notice of the character of money and popular language in reference thereto, as well as the various forms of money in the past as well as in the present. The value of the money of a leading foreign nation in terms of our own will likewise be judicially noticed by the courts. The courts will take judicial notice of the change in value of the dollar during a period of years and the steady and material decline in the purchasing value of the dollar. For example, the change in the cost of living is so much a matter of common knowledge that the jury or the court, when fixing damages, or the court reviewing an award of damages for personal injuries or death, may take judicial notice of such change. So if a case has been going on for several years and now we've had this double-digit inflation going on, then you could have judicial notice of those economic conditions for this given time, it seems. Citizens of Florida versus a Florida Public Service Commission. That was footnote 47. There it is. Judicially notice. Interesting there. And here's the changes in cost of living or purchasing power of money is affecting damages for personal injuries or death. Effect of anticipated inflation on damages for future losses. Modern cases. Got some more there and references there for further reading. All right, we're on to section 68. Current financial data, interest, discount, and exchange rates. All right, we got liberty, absurdity. Greetings and welcome. Okay, so we're on to section 68. The courts regularly take notice of commonly known and easily verifiable information, such as current interest rates. Although a jurisdiction which has not adopted the federal rules of evidence has found that because the prime rate fluctuates, it is not a proper subject for judicial notice. So again, we're discussing the federal rules of evidence as laws of evidence, and not all states have adopted them directly, although they all incorporate them to some extent. Usually that they have more lax rules in the state. However, some states do follow the federal rules of evidence. This being the highest standard, is that's what we're learning here. Courts may also take judicial notice of the discount rate on 90-day notes and various other published economic statistics. Similarly, the effect that inflation has already had on the value of money over a specific period of time is judicially noticeable. So we've already gone over that one. In addition, a foreign currency rate of exchange is a proper subject of judicial notice. A rate of exchange is not subject to reasonable dispute, because its accuracy can be determined readily by resort to an authoritative source, such as a published rate of exchange. For example, numerous publications, including major newspapers, publish exchange rates. A court may also take judicial notice that most credit cards do not charge interest on sums paid within 30 days. So, a couple things here. Numerous publications. Now, publicizing on websites, how do we take judicial notice, might be a little bit more difficult than referencing newspapers. This is 1998, so of course there will be some updates, I'm sure, on the newer versions of the American Jurisprudence. However, the concepts are still there. It would just be a method of doing it. Publishing is publishing, authoritative source, right? As long as that can be agreed upon by both parties, that would suffice. The court may not, however, take judicial notice of the American Jurisprudence second edition desk book compound interest annuity tables for the purpose of determining values of a party's pension fund, as the desk book is not an authoritative publication, nor are its value tables a matter of common general knowledge. Yeah, you gotta have a subscription, right? That's pretty funny. You can't take judicial notice of the American Jurisprudence second edition desk book compound interest and annuity tables. It's not an authoritative publication, really, nor are its value tables a matter of common general knowledge. Well, that makes sense, but that's pretty funny. Right here in American Jurisprudence, deprecating themselves in this case, huh? All right, we're on to section 69, the facts relating to real estate and agriculture. All right, Liberty, you're missing an AT. Yes, sir, with the clipboard. Shame this, Bill Thomas says, shame this was written before cryptocurrency. Wonder where lines would be drawn there. The same places, authoritative. If it's disputed, then it's not going to be judicially noticed. There's a lot of other reasons, but I guess it would be how you articulate your point of where the cryptocurrency has that nexus in the case. Okay, let's proceed here on the facts relating to real estate and agriculture. The court may take judicial notice of the effects of major economic events on real estate. For example, that foreclosure sales of mortgaged real property and the rights of parties to mortgages are affected by economic depression, or that land values are deflated following a real estate boom or during a period of depression, and that the rapid rise of real estate prices has a severe impact on the availability of affordable housing for the poor and elderly. Oh boy, this one's really evolved a lot, I know. Likewise, courts frequently take judicial notice of a variety of factors which have a bearing on the value of real property, such as the relation of sale price to market value of real estate. That a smaller tract of land might be expected to sell for a larger amount per unit of area than a larger tract. That construction of apartment buildings in a neighborhood previously zoned for one-family residences. Interesting, they say one-family residences. It's supposed to be single-family residences, meaning it could be a single person or it could be a family. And buildings for educational, religious, and similar purposes will adversely affect the surrounding residential dwellings. This must be specific from the case itself, the wording here. Footnote 62. That's Philister versus Minneapolis, or it could be Hayes versus Gibbs. Yeah, okay, that would be it. All right, let's continue. That small businesses have difficulty in obtaining tracts of timber within their purchasing power, and that building costs have increased over the years. The courts are often reluctant to take judicial notice of how such factors have affected the specific value of particular pieces of property. Yeah, they can only note other things that are true facts, but they can't take notice of how such factors have affected the specific value of particular pieces of property or the actual financial value of a given parcel of land. Similarly, courts may take judicial notice of increases and decreases in farmland prices, the depressed state of agriculture generally, and fluctuations in commodity prices. Other matters regarding real estate of which a court may take judicial notice include the facts that payments on real property purchase contracts are often delayed by 2 or 3 weeks, and this does not upset most creditors. So yeah, payments on real property purchase contracts are often delayed by 2 or 3 weeks. So we shouldn't hear any fuss in that time because it does not upset most creditors, and that can be judicially noticed. A home which is in need of substantial repairs at the time of sale is worth considerably less than one which does not need such repairs. Title searches and conveyancers customarily search title for only 60 years. Why 60? And until a warranty deed is found in the chain of title. Till a warranty deed is found in the chain of title. Title searchers search for 60 years until a warranty deed. Mortgages frequently run for many years. The transfer of title to real estate requires anywhere from a few weeks to a period of months. So the transfer of title from a few weeks to a period of months? Wow. It is common practice for a wife to join in her husband's conveyance of his separately owned property to assure that she will not later make a claim of homestead rights, and that 1/2 acre tracts is a particular locality. 1/2 acre tracts in a particular locality are ordinarily not profitable for agricultural use. In a particular locality, okay. The cost of fixing up houses and rental values in particular county do not, however, fall within the categories of for proper judicial notice. So the cost in a particular county and rental values in a particular county do not fall within the categories of proper judicial notice. So county is the word here. In addition, a sworn declaration from an appraiser stating that in the appraiser's opinion, the creation of an assessment district will not result in an increase in market values is not a proper matter for judicial notice. Opinions do not belong. Notice this fact. And we're on to section 69, the facts regarding relating to real estate and agricultural supplement. So now we get the 1998 supplement on all that. So that was all pre-1998 for the most part. Now we get to the 1998 supplement. And our footnotes here is it. Let's jump over here to the chat, see if we have anything here. Pandora's gifts, laws, please. Only for who? No, he helps unless. I don't know about that. I think a lot of this stuff has to do with knowledge, not money. But that's why we're here to see how these cases have actually played out. Knowing the game is part of the way of winning, and this is how it's essentially the rules are laid out. Don't like to think of it as a game, but there are rules. So let's look at this here. Refusing to judicially notice the economic impact of inflation on a particular parcel of real estate in family dissolution action. Here, although an appellate court can judicially notice that land values have increased during previous 10 years, it cannot take judicial notice whether a particular parcel of land is worth more than the amount it had been specified in an option clause in a contract entered 10 years earlier, because there is no evidence as to whether the price in that contract was unrealistically high or low when it was signed. So you can't take judicial notice of that. Wow, okay, that's an interesting one there. A court cannot take judicial notice of the market value and liquidity of tracts of real property. Market value and liquidity, yeah, I can see why. That would be argued. Let's see here. Request for advisory opinion concerning construction of House Bill 1388. All right. Okay, we're on to Section 70, the value of personal property, stocks, bonds, and investment capital. Oh, man. This one should be interesting. Let's get right down to it here. Courts will not, as a general rule, take judicial notice of the value of articles of personal property, since innumerable factors affect their value. Courts may, however, take judicial notice of certain matters or facts of general knowledge which affect the value of personal property. For example, the courts have taken judicial notice of the fact that stock in closed or closely held corporation has no recognized standard market value. Closed or closely held corporation. So this has no recognized standard market value. Now, this might apply to something like crypto too, that when you think about it, because what is it more than just a private ledger? And how that might apply there. Can it be judicially noticed? Is it common knowledge? Those would be the questions. Courts have taken judicial notice of the earning power of investment capital, the availability of high yield investments. The availability, wow, judicial notice of the availability of high yield investments, and facts relating to the purchase, sale, acquisition, and value of stocks. In addition, a court may take judicial notice of what was or is the fair value or earning power of money safely invested at a given period of time, and of the reasonable return on invested capital. A court may, but is not required to take judicial notice that stock market reports of certain newspapers and trade journals are trustworthy and reliable. Could we substitute websites here? Although where a party fails to introduce evidence of the price at which a stock was traded on a particular date, it is improper for the trial judge to take judicial notice of that fact. Wow. Party fails to introduce evidence of the price at which a stock was traded on a particular date, it is improper to take judicial notice of that fact. That's interesting there. Here's a comment. A court may, however, take judicial notice that an expensive vehicle, such as a Porsche, is especially vulnerable to theft in New York City. 1998. What was that? Porsche 928 or something, right? 98. Hot car in New York City. Judicially noticing that an interest rate of 3% is less than that paid by savings bank and much less than the usual rate on loans on real estate security, and is therefore less than the value of the money's worth. Most state and municipal bonds are purchased as investments. Prices commonly quoted for stock exchange transactions do not include taxes incurred in the actual transfer of shares. Acquisition of stock to acquire control of a corporation is frequently made at a premium prices. That could be judicially noticed. All right, that's great. That takes us to the end of this section here, and we're on to the next section, which will be historical facts, which will be starting on the next episode. Let's get over here to the chat. Let me refresh this here and see if we're all up to date. And I think we are. I'd like to thank everyone that came out tonight. I know we had a pretty thin crowd. It is holiday time, so I can understand why. But I do appreciate Liberty Absurdity for coming out here. I think it's the first time seeing you here, so really appreciate having new faces here. And also, we had Pandora's Gift, so welcome to you too. And a lot of our usuals here, Bill and Audit Them. Appreciate you guys all coming out. I hope we learned a little bit something here. And I hope everyone hit the like too on the way in to make sure we get the notifications out, because it has been pretty slim on the notifications. I'm glad someone out tonight. With that being said, I'd like to thank you all for attending tonight and going over the law of evidence, the economic and financial facts, so that we get a better understanding of where rubber meets the road when it comes to these kinds of issues, and to ensure that we're preserving what the heck? There we go. And ensure that we're preparing ourselves for any kind of incidents that might come about, to be able to preserve our freedoms and to ensure that it'll be there for posterity as well. If we don't exercise it, these kinds of things do tend to disappear in a bad way, as we've seen around the world. It's a good thing that we do indeed have American jurisprudence and this tradition here on America that at least gives us a reason to learn, to be able to preserve this for posterity and also to enjoy its benefits today. I'd like to thank you once again all for coming, and to have a happy Thanksgiving. Enjoy, and remember, it's because of this great land that we're able to enjoy the fruits of the pursuit of happiness as such. So peace out to you all. See you on the next one.